Good afternoon. We've waited a little bit to try and give everybody an opportunity to sign on, but I don't want to take too much of your time. Want to introduce myself. My name is Jay Wallace Irvin. I'm an attorney here at Lewis Thomason in our Nashville office within our construction practice group. For those of you, whether you're located in Knoxville, Nashville, Memphis, or elsewhere across the state, over the past few years, each of our offices have done an annual construction law seminar where we focus on a number of different topics. Due to COVID, we did not see that being a possibility this year, so we decided to take it virtually and do a series of webinars, one each month through from July to November, on a series of topics that we could have covered at one of the seminars that we do annually. Today we've entitled it Reconstructed, and today we're going to be talking about the Tennessee construction statutes and some of the legislative changes that have gone on so far. Part of that, as you may be aware, started last year in 2019 with a legislative effort to make some changes to some of the construction statutes and the construction laws that Tennessee has. Before we get into that, though, I want to point out a few things. One is, if you look on the Zoom taskbar, there is a chat section. So, you can hear me, but I'm not going to be able to hear you. If you have any questions while we're going through any of this, feel free to type them into a chat. I'll try and address those as we're going on, but if not, I'll be sure to hit them at the end of the presentation. It can be about this or something tangential. We'll try and address everything. The other is I have a little swag bag of Lewis Thomason paraphernalia that will go to the best. I hear lawyer jokes all the time. It'll go to the best architect or contractor or engineer joke that somebody can come up with. So once we get to the question section at the end of the presentation, type in a joke and I'll look at them, determine which one's the winner, and then we'll make sure somebody gets a grab bag of gear. So as we were discussing today, we're talking about the Construction Industry Payment Protection Act and the legislative changes that have taken place and been generated over the last 2 years. Before we get to that, it's important to understand when we say construction laws in Tennessee, what we're referring to. As you'll see on this next slide, there's 4 primary construction statutes within the state that Tennessee has here in Tennessee. Goodness, it's going to be one of those days. That Tennessee maintains. The first are the construction lien laws. That's in Title 66. Those generally deal with the right of contractors, subcontractors, architects, and engineers to be able to assert a lien for the labor, materials, and services they provide to a construction project. We have the Truth in Construction Act, which is a part of the mechanics lien laws. It's a separate chapter, but deals with really consumer protection. It's primarily geared for residential projects to protect the little old lady so she's not taken advantage of by a fly-by-night roofer who comes into town after a hailstorm. Doesn't have a whole lot of application to commercial construction, but we'll get into that here in a little bit. Probably the primary and most frequently used statute, aside from the lien laws, is the Prompt Pay Act of 1991. This is a statute that applies to written contracts for construction and design here in Tennessee, and is really a way to guarantee payment, or at least take steps to secure payment for labor materials that are provided to a project, as well as for design. And then finally, the construction defect statute, which is really a notice and opportunity to cure statute that focuses on the commercial construction industry. So getting a little more in depth and providing a little background, we're going to be talking about some of the changes that occurred this year in the legislative session, but it's important to remember what existed previously. Dealing specifically with the Tennessee lien laws, those statutes provide who is entitled to a lien. Whether you're a prime contractor, somebody that has a contract directly with an owner, or whether you're a remote contractor or a typical subcontractor. If you're an architect or an engineer, you can be both a prime contractor or a remote contractor. It just depends on who you're contracting with, whether you're contracting with the owner, whether you're contracting with an architect that's serving as the primary designer, an engineer that's serving as primary designer, or if you're a subconsultant. In those instances, you'd be remote contractors. The Tennessee lien laws also provide several notice requirements that have to be met for remote contractors, providing a notice of non-payment within 90 days of each month where labor, materials, or services are provided and performed, but for which you've not received payment. Requirements to record and serve a notice of lien within 90 days following completion of the project, not substantial completion, but completion of the project, as well as enforcement mechanisms, where you can enforce the lien, which courts, how you go about doing that, and the time periods in which those lien enforcement actions must be brought. That's 1 year for prime contractors, again, from the date of completion, or 90 days from the service of a recorded notice of lien if you are a remote contractor. With the Truth in Construction Act, again, I don't want to get too involved in this because of some of the changes, but this is primarily a consumer protection statute. It required a pre-construction notice to an owner of a contractor's lien rights as well as the lien rights of its subcontractors. It provided a form for a waiver, final waiver of lien, and provided that there was a restriction on choice of law. A lot of times in contracts, you will see that someone wants the law of another state to apply. In Tennessee, on construction projects, the law of Tennessee must govern, and that's one of the provisions within the Truth in Construction Act. Moving on, we have what I says current Prompt Pay Act. It's really the former Prompt Pay Act, but that is an act that applies only to written contracts, not to oral contracts. That's a principal requirement. It contains payment terms, a general requirement that a party pay its contractor, or a prime contractor pay a remote contractor within the terms set forth in the contract, whether that be 30, 45, 60 days or longer. If it's a pay if paid, pay when paid, those provisions will control, and that statute allows for that. It also says that if there's not a payment term within the contract itself, that the payment terms are going to be default net 30. In addition to progress payments, it also provides for the withholding of retainage. Some of you may remember 10, 15 years ago, that was 10%. About 8, 9 years ago, that was reduced down to 5%. And the way retainage was held and required to be paid changed back then. That retainage must be placed in a separate interest-bearing escrow account, and it has to be paid within 90 days of substantial completion, no questions asked. The only caveat to that would be if there is a legitimate default of a prime contractor or a remote contractor. Those sums can be used for other purposes, but it's still one of those things that is being litigated. To be able to take advantage of some of the Prompt Pay Act benefits, that being interest, attorney's fees, being able to seek injunctive relief requiring another party to either release retainage or release progress payments, you have to provide a 10-day notice to give them. It's just like if there's defective work, providing notice and an opportunity to cure. And then in terms of applicability, it applied to any commercial construction project over $500,000 with the penalties that you could get if, for instance, with retainage, if retainage was not placed in a separate interest-bearing escrow account, there's a $300 per day penalty, as it used to be known, that would continue to accrue from the first time retainage was withheld until it was actually paid or deposited into a separate interest-bearing escrow account. The big caveat with the old Prompt Pay Act was that it did not apply to banks, financial institutions, insurance companies, or other lenders generally. Finally, the former construction defect statute was a statute that I say was rarely used. It applied only to the commercial construction industry. It had very lengthy times. A lot of times in most form contracts and particularly with custom drafted contracts, there is normally a limited period for notice and opportunity to cure, some as short as 24 hours, more often 72 hours, 48 hours to provide an initial notice, and then the remote contractor or the party that's in default has to immediately commence efforts to cure and continue those to the contractors or to the owner's satisfaction until that defect is taken care of. Again, it's a statute that was only applicable to the commercial construction industry. It was internally inconsistent. As we'll talk about here in a few minutes, a lot of these statutes over time had been amended on a piecemeal basis, meaning that only one section of each of these individual statutes was addressed at any given time. Not frequently, the effects of those changes, could be drastic. It wasn't a comprehensive change to make sure that because these acts are interrelated, use the same definitions, that there was a lot of instances where there were inconsistencies, and it just created issues when you were trying to litigate a particular issue. If one statute said one thing and another statute said another, trying to figure out which one controlled, or even particularly with this statute, how you would address it when the definitions continued to change. So when we're talking about some of the legislative changes, it's important to understand why we're where we're at now and how we got here. So Tennessee operates on a 2-year legislative cycle, meaning at the beginning of each legislative session, there's a number of bills that can be filed. During the first year, if a bill is not passed by the legislature by the end of the session, it automatically rolls over into the second year, so that you don't have to refile bills every single year. 2019 was the start of one of these 2-year sessions, and at that time, an organization with the American Subcontractors Association had introduced a bill that sought to make a number of changes to the construction statutes here in Tennessee. We'll talk about a few of these. One was inserting new definitions, not only for subcontractor and work completed. These are phrases, particularly subcontractor, that were present in prior versions of the mechanics lien laws, but were eliminated when Tennessee simplified its lien laws. Instead of referring to general contractors, subcontractors, architects, engineers, surveyors, going to a system that was strictly based on whether you had a contract with the owner or not, and turning that into prime contractor and remote contractor. So it introduced a little bit of ambiguity. And then also with work completed, that's a phrase that's actually not utilized within the construction statute. So it raised a lot of questions as to why that was being done and how it would affect some of these other statutes. It also attempted to make some substantive changes to the mechanics lien laws, providing benefits to remote contractors, in that under the former and current mechanics lien laws, a remote contractor has 90 days. It's typically a 90-day rule for everything. You have 90 days from providing labor, materials, or services and not being paid to provide a notice of non-payment. You have 90 days from completion to record and serve a mechanics lien, and then you have 90 days from the date of service to be able to go ahead and file a lien enforcement action. That bill sought to extend that time period to 120 days to provide a little additional relief when a contractor is actually going through the process of asserting and enforcing a lien. 90 days can go very quickly, and as I'm sure most of you all know, if you are a subcontractor or if you do work as a subconsultant in the design context, that very often your contract may say 30 days, but more often than not, you're looking at 45 to 60 days in terms of receiving payment. So it requires you to make a quick decision and be very proactive in trying to enforce and assert those liens. So extending that provided a little bit of a benefit in those circumstances. It also, as I said, it extended the deadline for most of those requirements to 120 days. It actually extended the deadline to record a lien enforcement action to 1 year, the same time period that a general contractor has. Some of the more contentious portions of that bill were that it required the payment of retainage within 30 days of substantial completion. Right now, that is 90 days, which used to be that there was no deadline on that. An owner could essentially hold retainage until they resolved any sort of disputes with general contractors and any of the remote contractors. A number of years ago, that was put into place to have a finite deadline of when retainage had to be paid. Part of that was because you will have site contractors. If you have a geotechnical engineer, their work is done at the very beginning of the project. And it was not uncommon for them to be waiting, upwards of 2 years to be able to get the final 10% and here more recently the 5% that they would otherwise be due. And so it sought to reduce that even more to 30 days, which received a lot of pushback from both owners and general contractors. Also, probably the most contentious aspect of that bill was it sought to invalidate pay if paid clauses in Tennessee. Just for those of you who are not intimately familiar with pay if paid clauses, there are actually two contingent payment clauses in Tennessee. One is a pay when paid and the other is a pay if paid. A pay when paid clause essentially is a timing provision, much like a net 30 or net 60. It says, I'm going to pay you when I get paid. There's a guarantee of payment. It's just delayed until an owner makes payment. If an owner doesn't make payment, courts construe those to requirement payment within a reasonable time, which most people assume to be about 90 days in most cases. The final aspect of this was that it introduced a stop work provision. The stop work provision, some of you may be familiar with. It's frequently in form contracts as well as sometimes in some of the custom contracts, but it allows a contractor or a designer to stop work if they do not receive payment. Most owners try and get rid of that. They want to have a continuation provision in their contracts that requires you to continue work notwithstanding any sort of dispute. The key here was with a stop work order, that the dispute can center on anything. If you're not getting paid, it's the principal method. Why should you be required to continue to provide labor and services? So as you can imagine, this was a bill that was heavily contested by a number of industry groups, not necessarily in total. There were bits and pieces that different organizations had a problem with, and so it ultimately did not pass in 2019. Instead, it rolled over to what's called a summer study. It's where the sponsors of the bill try and get all of the relevant stakeholders together to try and see if there's some sort of compromise that can be had. So in June of 2019, Senator Jack Johnson, who was the sponsor of the original bill, called all of the construction trade organizations to a meeting over at the Legislative Plaza. In addition to the contractor organizations, architects, and engineers, they had a number of lawyers from the Tennessee Bar Association, and I was lucky enough to be one of those, but it was intended to discuss an amendment to the bill. Not so much can we reach a compromise, but it was more of a streamlining of the bill to only address the prohibition of pay if paid clauses and the stop work notice procedure under the bill. What we realized was, as we got in there, you had every organization represented. Every party to a construction project was within the same room and all interested in solving a problem. They just didn't know what that was at the time. So the general contractors organizations were there, the AGC, the ABC. You had the American Subcontractors Association that was present, the AIA, the engineering associations, TSPE, ACEC also present, the state of Tennessee, the architect's office, everybody that could theoretically be a part, as well as the Tennessee bankers I failed to mention, but everybody that could be a part of a construction project was within the same room. And so we started to focus on, well, we have this one issue, but we also have a lot of common interests here. Is there something we could do instead of just focusing on this one particular issue that one group has? Is there something the industry can do as a whole? As I mentioned earlier, over the years, the Prompt Pay Act, for instance, was originally enacted in 1991. So over the past 30 years, there have been numerous revisions to the Prompt Pay Act, but they have been on a piecemeal basis. Somebody would come in and say, well, we've got a section or two here. We've got 2 or 3 sections here. There really weren't any true substantive amendments to the mechanics lien laws, for instance, from when they were enacted until about 2007. There were a series of amendments after that. The Prompt Pay Act, again, had intermittent revisions over the years, but there had not been a comprehensive look at all of the construction statutes in Tennessee. And again, the problem with attacking it piecemeal is that you don't always understand what the unintended consequences of the change are going to be. So there were frequently situations where attorneys representing contractors, remote contractors, and designers would go into court and hit just roadblocks along the way, because a court would look at it and say, well, this statute says one thing, but how do we reconcile it with these other 2 that say something different? How do we resolve this ambiguity? And instead of the industry leading the charge on this is what the statute was intended to say, you have a court now, trying to insinuate what should be the law, as opposed to what the parties originally intended when those bills were passed. But getting back to that meeting, we started talking amongst the contractor groups and amongst the designers in the state of Tennessee, and said, well, what is the problem? We have an association here that itself is having issues getting paid, and that's what it's seeking to protect. But what we really need to make sure of is that the construction industry as a whole has adequate payment protections, whether it be the designers, whether it be the suppliers, the general contractors, or the subcontractors. We have issues that we have these current construction laws in place that are all intertwined and provide us some protection, but they're insufficient. They're inconsistent. One provision says one thing or gives one right, and it takes it away in another. How do we reconcile that? And most importantly, the risk of non-payment was not borne by the party that was best able to manage it. As frequently is seen within a lot of form contracts in terms of insurance requirements. Insurance is generally required to be borne by the party who's best able to manage the risk. Non-payment should be the same way. We have situations where, particularly with the Prompt Pay Act, that the lenders are the entities that are actually holding all of the funds. They're the ones that have the benefit of all the indemnity agreements, the credit applications. They're secured for any amounts that they loan the owner, but yet they're not subject to any sort of action by the contractors or the designers in the event of non-payment. It's trying to get blood out of a turnip. If you have an owner that you're seeking to recover from, but they haven't actually gotten any money from the bank, you can get a judgment against them. But again, on paper, it's worth about the value of the paper itself until you can either find some assets or find a way to actually reach the money that's being held by the lender. So how do you resolve that problem? Well, the first and most obvious was to cure all of the internal inconsistencies. Make sure that definitions that had been changed back in 2007 were actually carried through all of the other statutes. The second was to eliminate, or the goal was to eliminate loopholes in all of the relevant statutes. The Prompt Pay Act, again, is an act that historically was, the banking industry was completely exempt from complying with. You could not get an order, and even if it was a lender-owned project, if a bank was trying to build a new branch, the Prompt Pay Act did not apply. They were not required to put retainage in a separate escrow account. They were not required to pay on time. It was governed simply by the contract, which was generally one-sided in favor of the lender. The third aspect, and the more practical aspect of it, was to ensure that there were adequate timing, notice, and penalty provisions to protect the industry, making sure that interest was adequate, making sure that contractors had a way to facilitate communication between the parties. Because as we got into a discussion about what was the biggest issue, it was a lot of times there wasn't communication that was actually flowing from the lender to the owner, from the owner to the general contractor, and on down the contracting chain, or between the owner and the designer, and the same with the designer on up through the lender. So making sure those payment protections were in place. So over a number of months, from July through really the end of the year, and then on into March of this year, a number of organizations got together and had meetings where primarily it was a negotiation between subcontractors and general contractors is how it started out. It ended up going much broader than that and getting input from all of these organizations: the American Subcontractors Association, the Associated General Contractors of Tennessee and East Tennessee, the Associated Builders and Contractors of Tennessee and West Tennessee, the AIA, ACEC, TSPE, as well as I've got the LT hard hat there because I was designated as a liaison between these groups, but as well as the Tennessee Bar Association and some other legal organizations with lawyers that had an interest within the construction industry. So over that period of months, it was an interesting process to watch and be a part of. It started out where you had subcontractors going against contractors, both trying to figure out who was at fault for non-payment. You had situations where contractors would be saying, I don't understand what the issue is, I pay my bills all the time. And it was almost an aha moment. They both realized that neither of the representatives or any of the organizations that were a part of these negotiations were the problem. It was generally, lenders, owners, out-of-state contractors, people who were not familiar with the law and weren't following the law. And so in those instances, they recognized they needed a number of changes to help better manage the risk. Part of that, again, with communication, was that the Mechanics Lien Laws and the Prompt Pay Act provide some notices, but you don't always want to have to get a lawyer involved. Was there something that could be done to provide some additional notices and forms that an individual entity could use and start on their own the process of asserting a lien and enforcing their lien rights, or asserting and enforcing a claim under the Prompt Pay Act without having to go spend money on an attorney, when really all they needed to do was to start communication to figure out what the actual problem was. So they started looking at being able to add some of those notices and forms, as well as in terms of some of the other aspects they looked at, the right to stop work. That was still on the table. That was something that both general contractors and remote contractors felt was necessary to introduce into the Tennessee statutes. From a general contractor's perspective, they found that a lot of times it was beneficial to be able to go to an owner and say, look, we need to get paid because we've got these contractors that are going to stop work if we can't give them some sort of payment. When there was no dispute and it was simply a timing issue between the owner and the bank, or for whatever reason the owner didn't want to go ahead and make payment. Sometimes it was as simple as there was a payment application that was sitting on the desk that they just couldn't get to. It was just having an ability to be able to point out, hey, we've got people that aren't getting paid and they need to get paid, otherwise they're going to stop work. Kind of a supplement to that was a demand for reasonable assurances. This is something that is already included in many of the AIA documents, is where a contractor or a designer is not being paid. They have the ability to ask the owner, hey, we need some sort of evidence that you're going to be able to pay your bills, not only now, but in the future. Something off the beaten path here a little bit was making sure that in terms of statute of limitations and statute of proposed, that those applied uniformly regardless of how any sort of dispute was handled, whether it went to arbitration or litigation. As we'll talk about here in a little bit, construction lawyers for years have utilized the statute of repose, which in Tennessee is 4 years from the date of substantial completion. Any claim that relates to construction, whether it be on the part of a designer or a construction defect, has to be brought within 4 years of substantial completion. That was assumed to apply both to arbitration and litigation, but about 1.5 years ago, there was an arbitration award that came out and found that the statute of repose did not apply to arbitration. And so it was important to close that loophole to make sure that, when you're dealing with some of these form contracts that require claims to be brought within a certain period of time, that it applies regardless of whether you agree to arbitrate the dispute or whether you're in litigation, as is often the case. The final thing that was discussed was in terms of limitations of liability. In Tennessee, it's generally assumed that limitations of liability in construction and design contexts or contracts are going to be valid. There's a series of factors that go into that, one of which being that the limitation of liability not violate any public policy of the state of Tennessee. And so it was important to add some statement that those limitations would be valid, whether it be a specific monetary limitation or whether it be a waiver of consequential damages or a similar waiver that's frequently contained in construction contracts. So in terms of the actual changes themselves, one of the biggest changes that has a great effect for lawyers but is not really recognized by the industry generally is just the internal consistency between the acts. Back in 2007, as I mentioned earlier, Tennessee switched from a system where it designated each party by what they did as opposed to who they contracted with. That system was rather confusing because you never knew, depending on contracts where you were providing a service and materials, whether you'd be contracted or whether you'd be considered a supplier or a subcontractor. That was changed to prime contractor and remote contractor, but those changes were not carried through the remainder of the acts. And so and even within the lien laws themselves, there were several instances where the terminology was still dated. And so it was important to have internal consistency throughout the lien laws. As it stands today, the subcontractor's proposal to extend the deadlines to 120 days were not included in the final version of the bill, although that was something that I think in the future you could see. So just take note of that here in the next few years. There may be a push to try and extend those again, but for now, it's still the 90-day rule is going to apply for remote contractors. 90 days after providing labor and materials, you need to file, excuse me, you need to serve a notice of non-payment. You need to record and serve a notice of lien within 90 days of completion, and then filing a lien enforcement action within 90 days of the date of service of the notice of lien. The Truth in Construction Act, again, this is one that was primarily focused on the residential construction industry to protect people in the instances where most homeowners do not have a lot of experience with the construction industry. They have not dealt with contractors. They don't even know what a lien is. And so there were several provisions that really were geared to the residential industry that are appropriate, but they're not appropriate and not needed in the commercial context. With the commercial construction industry, you're most of the time dealing with sophisticated entities that this is not their first time around the block. It's certainly not their first construction project. They understand the contracting process. They understand mechanics and materialmen's liens. And so it was important to remove some of the onerous record-keeping requirements and notices that were required under that act from the commercial context. Very candidly, it might have been 1% of the construction industry, at least in the commercial context, that I was aware of, that contractors or designers even attempted to comply with that. Most of the time, it was within the roofing industry, just because that was a heavy target for a lot of the consumer protection claims that arose. And so a lot of times in the roofing industry, you saw on their standard form contracts, references to the statute, but outside of that, it was very minimal. The issue with that is that previously, if you did not comply with that, the non-compliance was deemed a misdemeanor. I'm only aware of a handful of cases where an attorney general or a local criminal lawyer tried to actually enforce that. There's very few that actually went through. And again, in the residential context, that makes more sense, but certainly not in the commercial context, where you're previously seeking to penalize somebody for not notifying an owner of something that they're already aware of. And so as part of these changes, the criminal penalties were removed from the commercial context. Those notice requirements were removed. There's still one provision of that act that is going to continue to apply, and that's the choice of law provision, just requiring that Tennessee law apply to any construction project that goes on here in the state of Tennessee. Now, probably the biggest hot button or the biggest topic of any of these discussions was the Prompt Pay Act here in Tennessee. And as I mentioned earlier, this added a number of notices and forms. Throughout the Prompt Pay Act's history, you've always had the right to seek injunctive relief, meaning you can go and get a court order that requires an owner or a contractor to do something, whether that be to make payment, whether that is to execute a release for the retainage, so that a bank can release retainage to the general contractor. If it's requiring compliance with progress payments, if it's to get a general contractor to go ahead and submit a final pay application, there was really no limit other than that you provide that notice. What caused some problems was that language was a little ambiguous, and lawyers frequently had issues going into court to be able to get an injunction. So one of the things here it did was, if you had a remote contractor, it wasn't clear if they could go straight to the owner, or if they had to go through the general contractor before they could get their money. And with these changes, it's very clear that a remote contractor or a general contractor may seek injunctive relief to try and obtain relief under the Prompt Pay Act. There was also an issue previously, as I had mentioned, non-compliance with several of the retainage provisions gives rise to a $300 per day penalty. And it was referred to as a penalty in the Informer Act. The problem with that is that a judge here in Davidson County found that there was a constitutional issue there in terms of how long that penalty could accrue. She found that, even though a project may go on for 3 or 4 years, and even though an owner may have that money for 3 or 4 years and not place it in a proper retainage account, that you were limited to 1 year of penalties. The penalties, if you add them up, come out to about $108,000 a year, which can be substantial over the life of a large project. And so having that be defined as a penalty was causing some issues, and took away a huge bargaining chip for contractors and designers in the event an owner was trying to withhold money. So one of the changes was changing that phrase just simply from penalties to damages in an attempt to try and get additional monies and relief if an owner is continuing to hold on to any sort of progress payment or retainage. Another was simply the interest rate. The interest rate under the Prompt Pay Act has changed a number of times. About a decade ago, it was set at 10%, which is the general prejudgment interest rate here in Tennessee. 10% is a fair rate. Sometimes that rate was reduced by contract. Sometimes, a lot of times with material suppliers, you'll see it as 1.5% per month. The issue with this act is there's actually 2 Prompt Pay Acts in the state of Tennessee. One is specific to construction, which is what we're dealing with. And then another is dealing with general purchases by the state of Tennessee. If the state of Tennessee buys ballpoint pens, desks, wallpaper, you name it, they pay 18% per year, 1.5% per month. And so the question came up, well, if the state is paying interest at 18% on ballpoint pens, why should the state not pay 18% on a construction project if they're not going to pay timely? And so the follow-up to that is, well, if the state's going to pay 18% interest, every owner should be willing to pay 18% interest. And so you went from the 10% that it was years ago. A few years ago, it went to a prime plus, where right now it changes every 6 months. Right now, I believe it's 5.25% if you were going off the state rate. And so in terms of large construction projects, the interest rate at that low of a rate really doesn't provide any incentive to an owner or a general contractor to go ahead and make payment. And during these discussions, some of the general contractors were very candid, where they would say, well, with interest so low, I can borrow money for less than what it would be to pay this interest rate. It makes sense for me to just go ahead and eat that. I can borrow money, I can tide it over until I get everything resolved, and then go ahead and pay it. What was more often the case was that nobody paid interest. A lot of cases settle, and so there really was an incentive to have that low of an interest rate. So one of the big keys was raising that from the 5.25% that it is currently. In the new statute, that jumps up to 18%. Again, we talked a little bit about the demand for adequate assurances and the right to stop work. Those were both provisions that were added, and we'll talk about it a little more in depth here in a few minutes. And with all of those, the general contractors, the remote contractors, architects and engineers as a whole, the industry feels that it was able to better manage the risk of non-payment through all of these changes. As we talked about, in terms of the removal of the cap on damages, this was simply replacing the term penalties with damages, and making sure that with an added sentence that you see there at the bottom, that it's the intent of the Prompt Pay Act that the damages for non-compliance with retainage will continue to accrue from the first date they were retained until they're placed in a separate escrow account or otherwise paid. Hopefully with those 2 changes, contractors and designers will not be limited to to 1 year of damages, you know, the $108,000 if you're the geotechnical engineer or the site work contractor who has your money being held for a number of years. If it's not being held properly, you know, you're going to be able to see significant damages from the owner for the non-compliance, or if the owner doesn't comply with that, from the general contractor. Again, in terms of the right to seek injunctive relief, there's a number of provisions throughout the Prompt Pay Act that allow for that, both in 104, 205, and penalty, or the damages section, and the section that deals with injunctive relief, 602. Some of the clarifying language that you see here was necessary because a lot of times you would have an owner who would come in and say, well, I'm not required to pay the general contractor because the general contractor filed for bankruptcy. Or you would see a lender say, well, we're not releasing any more money because we have an owner that's insolvent. There's a new provision, that 205C, that makes clear that despite a bankruptcy, you know, that cannot be used as a defense to non-payment. Even if somebody within the contracting chain files bankruptcy, you know, those monies have to be paid to the party that they're due. Tennessee is a trust fund state, which means that anybody that receives money on account of a construction project is holding that money in trust for the party to whom it's due. So if a contractor receives a $100,000 payment, if it's only entitled to 20%, you know, a bankruptcy court or a bankruptcy trustee is only going to be able to reach that 20%. That's the current law, but there is some confusion about that at the trial court level. So this provision will hopefully clarify a lot of that to make sure that the money goes where it's intended. Again, interest has been increased to 18%, and under 602, as we were talking about, in terms of notices, you're required to provide notice that you intend to seek relief under the Prompt Pay Act. Historically, that had to be done by certified mail. There was a revision to the lien statutes a number of years ago that allowed for commercial delivery, whether it be FedEx, overnight, UPS, however, any sort of delivery service that provides written confirmation of delivery will be sufficient. That allows you to, if you get in a bind and you're at day 88, 89, and you don't know that you're going to have that notice served under the lien statutes, you could go ahead and do it by overnight mail. The same thing holds here true. Instead of having an additional 3 days that you have to wait to be able to seek relief under the Prompt Pay Act, this way you can start your clock ticking a little earlier by being able to deliver that by overnight mail. In terms of notice forms, again, one of the biggest complaints that we receive from subcontractors and subconsultants was that we don't want to have a lawyer. We don't want to have to engage a lawyer to be able to do some of this preliminary stuff. Is there something we can do on our own? What we really need is just a form. We can send it, but we didn't go to law school. We need to have some way to be able to process these forms. If there was a notice form, that would be fantastic. So a new subsection to 602, just underneath the requirement that the notice be provided, is a specific notice form that, very much like a notice of non-payment, provides notice of the intent to seek relief under the Prompt Pay Act. Another new section that we touched on briefly earlier is the stop work section. The goal with the stop work notice was that, in many of these forms, was instead of having to send multiple letters, you could have one letter that addressed everything. You know, notice of your intent to seek relief under the Prompt Pay Act, notice of your intent to stop work if you don't receive payment. One of the key requirements in terms of a right to seek relief under the Prompt Pay Act is that you provide an owner or general contractor or whoever you've got a contract with notice of your intent to seek relief. If you don't receive a response within 10 days that sets forth adequate legal reasons for non-payment, such as a true default, or if the owner says, well, you say you're owed $100,000 because you're 50% complete with your work, but we think it's only 25%. If there's a legitimate dispute, you know, that gives them an opportunity to defend against it. But the key was trying to make all these timelines line up so you could send one notice without having to send multiple to try and address multiple issues. It could all be taken care of in one shot. So the stop work notice can be tied to a notice under the Prompt Pay Act, where you say, if you don't provide me notice and give me adequate legal reasons for the non-payment, I'm going to be stopping work. That applies both for a prime contractor as well as a remote contractor. They can send those letters, and if they're not paid, they can go ahead and stop work. The flip side of that is that if they do stop work, it can be a very difficult decision to make, because if you stop work and you don't have a legitimate reason, or if there is some defense, there is a potential that you could be subject to a breach of contract action as a subconsultant or as a contractor. But assuming there is none, if you end up getting paid, you're off work for 5 days and an owner goes ahead and makes payment. A lot of contracts require you to be bound to the project schedule and to complete the work in a timely and efficient manner. The key here is that the statute actually provides an equitable adjustment of the schedule so that you can't be tied to the initial schedule if the cause of the delay was actually caused by the owner. And that goes along with the general prevention doctrine, which is if an owner is preventing you from completing your work in accordance with the contract, they can't rely on their own breach of contract to require you to do something that was originally required if they're the cause of the delay. Demand for reasonable assurances, when you go through this, you'll notice it seems eerily similar to the AIA documents, and that's because it is. It's one where prior to visible commencement, a prime contractor can make a request for reasonable assurances to know that the owner has adequate financing in place to be able to pay for the project. And not only the project, but for any contingencies or foreseeable changes that could arise during construction. After visible commencement, both a prime contractor and a remote contractor, if the owner fails to make payment, can make that request of the owner to provide adequate assurances of their financial arrangements. Like the AIA documents, there is a requirement that the owner not vary the financial arrangements that they've made without prior notice to the subcontractors and the general contractors. Similar to the stop work notice and the notice of non-payment, there's a new form for contractors and designers to use to be able to say, in the event of non-payment, you can copy and paste it into a letter and make a request of the owner. Again, like all of the other notices within the Prompt Pay Act, there is a requirement that they provide a notice within 10 days. So that, if you end up not being paid, you can immediately go to court and seek injunctive relief, whether that's for payment of a progress payment or for any other relief that you may have, including payment of retainage. Now, one of the big changes that was sought within the Prompt Pay Act was the removal of the blanket banking exemption. As you can see here, historically, lenders, insurance companies, savings and loans, credit unions, insurance companies, any sort of financial institution was exempt from the Prompt Pay Act. I mean, it didn't apply to their own projects. It did not apply if they took over a project in the event of an owner default. If they were holding retainage and you couldn't get an owner or a general contractor to pay, there was no way for you to actually require the bank to go ahead and pay that money either into the court's registry or to the contractor or remote contractor that it was to whom it was due, despite the fact that Tennessee is a trust fund state and says that is money that belongs to somebody else. There was no way to enforce it. You had a right without a remedy. And so initially during these conversations, the industry attempted to just completely eliminate the exemption altogether. That was met with some very strong opposition by the Tennessee Bankers Association. But through a number of amendments that they tried to pass, they would propose language that essentially just restated the banking exemption as it existed previously in an attempt to try and say, hey, we're negotiating here. We're trying to work with the industry to come up with a solution. But at the end of the day, it really was no solution at all. In March of this year, we finally came to an agreement with the banking industry on a simple exemption, which would say that the Prompt Pay Act applies to any sort of banking project. It would not require the caveat to that, and or if they took over a project. But simply said, the banker's primary objection was that they didn't want to be responsible for some of these damages, which were now going to be substantial in the event their debtor, the owner, was actually failing to deposit retainage into an escrow account, or trying to avoid arguments that somehow the lender was standing in the shoes of an owner when they should not have been. We had an agreement in March. As you know, the legislature went on a brief sabbatical for COVID. In April and May, which delayed the session. When they came back in June, the intent was that they were only going to be looking at budget bills or COVID bills. And so the industry saw, the issue was, we're coming to the end of the 2-year legislative cycle. We don't want to be in a situation where we lose all of these benefits that the industry as a whole has agreed to. And so is there something that we can do to try and come to an agreement with the banking industry? And so what I've titled the COVID compromise. We obtained a partial exemption, which is very similar to what we had previously, but required the insertion of some additional language in other parts of the Act, which watered it down a bit, but based on the language in 703 that we have now, should be sufficient to be able to go seek relief from any sort of lender. At the outset, it continues to say that the chapter does not apply to any bank, savings and loan association, which was the old exemption. However, you get into B and C, which says, notwithstanding the banking exemption, if a bank is acting as an original owner, meaning they're constructing their own projects, or if they take over a project due to an owner default, they are now subject to the Prompt Pay Act. That means they have to put retainage in a separate account. The caveat being they can hold it themselves in a separate account as opposed to doing it with a third-party lender. And you can seek injunctive relief against the lender as though they were the owner. That actually applies, and the right to seek injunctive relief actually still applies to a lender in their capacity as a lender. You can't seek damages against them. The only thing you can require is that they go ahead and release retainage pursuant to a court order. So if you go in and say to a court, this lender is holding progress payments, they're holding unpaid construction proceeds, whether it be progress payments or retainage, they should be required to deposit those in the court's registry. It allows the bank an opportunity to place it in the court's registry and then throw up their hands and say, our business here is done. But at least it gets the money out of the bank's hands into the court's registry, at which point, the designers and the contractors are much more likely to be able to take their funds out that belong to them. It's not discussed in this presentation, but historically there was also a requirement that if you sought injunctive relief, you were required to post a bond twice the amount of what you were seeking to get. Now it's reduced to only the amount you're seeking to get, which removes a big hurdle for a lot of smaller subcontractors and subconsultants, but provides an opportunity again to be able to get those sums from a lender. The final aspect of this is, again, just clarifying that a lender is not going to be responsible and will not inherit liability that an owner, if they are in default, had previously by not putting retained sums into a separate escrow account. It's one of those that did not come up a whole lot, and so the industry didn't see that giving that away provided them any real detriment. The key was, as long as we're able to go after the lender and be able to get the money that is rightfully ours, we've succeeded at this point. I expect that there will be some more changes in the future, but again, right now there's been a lot of changes for the benefit of the industry. We're running short on time, so I'm going to go through these last two items relatively quickly, and then we'll have some time for questions. But initially, in terms of limitations of liability, generally these are enforceable within the state of Tennessee, at least in the construction context, as long as you satisfy the factors that go into whether it's permissible. The key being, is it against the public policy of the state of Tennessee? That was something that was difficult to ascertain because that's generally taken from the legislative history, which there's not a lot of here in Tennessee in terms of the Prompt Pay Act and the other construction statutes. And so as part of these changes, the industry inserted a statement that without limiting any other law or existing regulation, it is very clear that it is not against the public policy or the public interest of the state of Tennessee to have a limitation of liability in either a construction contract or a design contract, as long as the limitation bears a reasonable relationship to the contract and is a reasonable monetary amount. And that can be either for a portion of a fee if you're a contractor on a cost plus, or a portion of the fee for the designer. It can also be a specific monetary limit, $100,000, $50,000, $500,000. that's still going to be something, whether it's reasonable or not, is a determination that will have to be made by a court. But at least in terms of the public policy side of things, you know that that is something that's not going to matter for a court when they're looking at it. In terms of the construction defect statute, the changes were very similar to those that were within the lien laws. It got rid of a lot of the internal inconsistency, making sure that the definitions were up to date, but really didn't have any major changes as it applies to construction defects. That's because that statute is really not used that often. I'm only aware of 5 or 6 times in the past 15 years that it's been at issue. And really the reason is because most construction contracts already have a notice and opportunity to cure provision and a process by which defects can be, or a contractor can be notified of defects and have those taken care of. Taking this to its limits, this statute can take on a large project up to 6 months to go through the process of passing notice down the chain, getting recommendations back up, submitting settlement offers. It can be unmanageable. And so the industry, given the amount of time, decided not to take any substantive changes with that statute. One of the biggest in terms outside of the Prompt Pay Act is ensuring that the statute of repose applies uniformly, regardless of whether you're in arbitration or in litigation. This was done by a series of amendments. Previously, it said an action had to be brought within 4 years of substantial completion. An action was generally defined as a court proceeding, as opposed to arbitration. Arbitration was outside of the scope of that definition. And so instead of altering the definition of action, we just added that it doesn't matter if you're in litigation, arbitration, or any other form of binding dispute resolution, leaving it wide open. The statute of repose is going to apply to construction contracts and construction claims here in the state of Tennessee. Again, that allowed for uniform applicability, allows for a lot more certainty when you're contracting to know that regardless of how you choose to resolve your disputes, that you're going to have some outer boundary for construction claims here in the state of Tennessee. So that's a lot of information compressed into a limited amount of time. I've seen that we've had a couple of questions here, and I'll try and address those shortly. But you know, as we move forward, my contact information is down there at the bottom left. You can feel free to email me or give me a call at any time if you have any questions. I'd be happy to answer them. Another point I want to make is that this is the first in a series of programs that we're putting on in lieu of having an in-person seminar at each of our offices. We'll have one each month, and the topics are governed there. I understand that for the architects out there, we are working at getting these certified by the AIA to provide learning unit credit, and we'll keep you posted on that. Just again, if you have any questions, feel free to go ahead and post them in the chat area.